I mean, all three of these are.
All right, well, I'm gonna go ahead and get started with the next section here, board and membership meeting. I like this slide here, little cartoon. Everyone here, good. Meeting topic, setting work record for shortest meeting. All in favor, say aye. Ayes have it, meeting over. Wouldn't it be nice if that's how meetings are? As you probably already know, we don't generally do that. So we're gonna talk about the types of board meetings, how to properly notice board meetings, what open meetings are, and how to meet in executive session properly, how to establish a quorum, voting and proxies, taking action outside of a board meeting, in recording and taping of board meetings. So board meeting procedures are governed by your governing documents. The Texas Nonprofit Corporation Act, codified as Chapter 22 of the Business Organizations Code. You've got the Texas Uniform Condo Act, which is Chapter 82 and sometimes 81 of the Property Code, and also Chapter 209 of the Property Code for subdivisions only. Now, here's the big picture. A declaration is a private contract that runs with the land and imposes certain contractual obligations on the owners that are subject to the declaration. You've got the obligation of mandatory membership, obligation to pay assessments, and the obligation to comply with the restrictive covenants. The mandatory membership in the HOA is what we're going to be talking about with respect to meetings. All right. Almost all HOAs are incorporated as nonprofits and managed by a governing body known as the Board of Directors. The Board of Directors is the brain of the corporation. It makes the decisions on behalf of the corporation by approving a motion at a meeting of the Board of Directors or by written consent of the Board of Directors outside of a meeting. Importantly, those are the only two ways that formal action by a Board of Directors can occur. You've got two kinds of board meetings. You've got regular board meetings. These are conducted on an ongoing basis, generally once a month, sometimes less, sometimes more, depending on your obligations. And they're generally for the purpose of taking action necessary for the normal, ongoing, daily operation of the HOA. Then you've got special board meetings, and these are meetings of the board called for certain special or limited purposes. Now, in condo associations, unless it's required by the governing documents, notice of board meeting is not required to be given to unit owners. There's exceptions to this. If the association receives a written request from an owner to know about when the next meeting is, you're supposed to tell them. If you don't know when the meeting is going to be after you receive the request, once the meeting is set, you have to tell them. There's a couple other exceptions to this that we will talk about now as well. The board meeting, if you have a board meeting where the board is permitted to modify the bylaws or even the declaration and sits for that purpose, there are special requirements where you do have to notify the members. Every owner has to receive a copy of the document showing what the change is that the board is going to vote on. You've got to give at least 10 days and no more than 20 days notice to the owners that that's going to take place. And there's some specific requirements how you deliver that information to owners. For subdivision associations, you have to provide notice of every single board meeting that you have. You've got to provide owners with the date, the time, the place, and the general subject of any matter that's going to be brought up for board discussion. You've got to provide that in certain ways. Sorry, trying to answer. There are two different methods for sending notice of board meetings to the owners. You can send written notice between 10 and 60 days prior to the meeting. Nobody does that anymore. Most likely what you're doing is you're posting and emailing a copy of the meeting notice to the owners. You post it on your website or in a conspicuous place within the neighborhood, but probably on your website. And then you email the notice to all the members that have registered to receive notice via email, which is something that's implied that you have to provide. You've got to give people a way to register their email address with you. It's got to be easy for them to find. Then you just have to send notice to those that have actually registered. This has to go out, and I cannot tell you why the legislature likes to count days in hours, but you have to send notice at least 144 hours, 6 days, you don't have to do the math, prior to the meeting, if it's a regular meeting, and 72 hours prior to the meeting, if it's a special meeting. So those are your requirements. Now, condo associations and subdivision associations can both have executive sessions, but the way that you do it is fundamentally different. So in a condo, you can have an executive session to talk about hiring or firing people that work for you, pending litigation, contract negotiations, enforcement actions against owners, matters involving the invasion of privacy of individual owners, or anything that anybody's asked to remain confidential. This is how it works. Prior to the executive session, in the open session, you've got to announce to everyone what the general nature of the business that you're going to talk about. Then you go into executive session, have your executive session, come out and vote. Now, in a subdivision association, a subdivision board can have an executive session about the exact same matters. However, what you do prior to the executive session is simply announce you're going into executive session. You don't have to tell anybody that's present what you're going to be talking about. However, following the session, any decision you make in the executive session must be summarized orally in general terms and put into the meeting minutes. The oral summary has to be a general explanation of all expenditures approved in the executive session. So you can't go into executive session to keep financial information secret from the owners. That all needs to end up in the minutes after you've made the decision. Now, you have to have a quorum of directors before you can take action as a board. The quorum is going to be recited in your governing documents, generally the bylaws. If it's not there, you can look to chapter 22 of the Business Organizations Code. And if you still haven't been able to determine what your quorum is, and you are a condominium, chapter 82 will tell you what your quorum requirements are. Now, if you are going to conduct a board meeting by electronic or telephonic means, these are general rules that apply to both condos and subdivisions. Each person participating has to be able to communicate with all others. And if you're going to vote at an electronic board meeting, then everybody needs to be able to be identified and a record of the vote needs to be taken. It's pretty easy to do an electronic board meeting via Zoom. You can know who's voting. Everybody can hear each other. You can have a debate and you can discharge your fiduciary duties over Zoom. Now, with respect to condos only, if you're going to have an electronic or telephonic board meeting, you have to give notice of the meeting to each director. It'd be pretty hard to have a meeting if you didn't. Each director has to be able to hear and be heard by every other director present. And you can't have an electronic or telephonic meeting to vote on a fine, a damage assessment, or an appeal from an architectural decision, or to vote to suspend an owner's right to use the common area before you've given them a hearing. If you've already given them a hearing, you can have the meeting by electronic or telephonic means. Now, there are some differences for subdivision association boards that are going to meet by Zoom or some of these other technologies. Similarly, each director has to be able to hear and be heard. And except for any portion of the meeting that's in executive session, all of the lot owners have to be able to hear all the directors, and they need to be given permission to sign in using the same method that the board members have been given. So if you're doing this by Zoom, that means your meeting notice that has to be posted on the website and emailed to everyone needs to include those Zoom instructions. That doesn't mean you've got to let everybody talk. They can be muted. There's no obligation to allow everybody their 3 minutes of time to yell at the board. What you can do is you can mute all those folks. They've got the right to be there in a subdivision association. They've got the right to hear you deliberating what your vote's going to be, but they don't have the right to interrupt you or otherwise speak if you don't want to give them that opportunity. Notice has to include the instructions, as I mentioned, and it has to be provided before the meeting begins. Now, we've got some conflicts between all these various statutes. The Texas Business Organizations Code in chapter 22 gives nonprofit associations some methods of conducting business outside of a regular board meeting. And the easiest way that you can do that is through a written unanimous consent. All the board members agree, they all sign a piece of paper that you don't have to have a meeting. However, this general rule is both limited, expanded, and confused by the property code. So in general, under the Texas Business Organizations Code, the board of directors of an association can take action without conducting a meeting if 100% of the directors sign a written consent. This is the same thing as a unanimous vote that happens at a board meeting. In a condominium association, we've got some limits. So unless it's otherwise provided by your governing documents, you can take action by unanimous consent outside of a meeting unless you're voting on imposing a fine, a damage assessment, or voting on an appeal from the denial of an architectural approval, or if you're suspending an owner's rights before they've had a hearing. Written record of the approval has to be filed in the association's records, just like meeting minutes. So meeting minutes are the record of all the formal action that an association has taken. If you take action by unanimous written consent, goes in the same place. Now, with respect to a subdivision association, you may not vote on any of the following matters unless it's at a properly noticed in-person board meeting. Now, I'm not going to read all 15 of those, but just understand that there's this list of 15 things that if you are a subdivision association, you may not deal with in an email vote, in an electronic meeting, in a telephone meeting, in any other way besides having an actual meeting where everybody can hear each other and vote. So with respect to a subdivision, you are permitted to have an electronic or telephonic vote if each director has an opportunity to express their opinion and discuss matters. And it does not involve one of the 15 types of actions that has to be taken at a board meeting. So basically that means you can conduct your board meetings via Zoom unless you're talking about those 15 types of actions. However, because a subdivision association is also organized under Chapter 22 of the Business Organizations Code, you may not be able to take full advantage of that provision. That's because the Business Organizations Code doesn't authorize boards to take action outside of a meeting unless it's unanimous. Chapter 209 of the Property Code does allow a homeowners association board to do less than unanimous written consent. And so you've got very conflicting information out there. Does the legislature want to allow that, or does Chapter 22 need to be amended? We don't know. I would simply suggest that if you're taking action outside of a meeting, and a lot of boards are voting by email these days, it ought to be unanimous. I would not recommend taking action outside of a board meeting for any reason at all, unless it's an absolute emergency, unless all the board members have expressed their unanimous consent.
Can you go back to the 15, please?
Will this slide deck be available?
Yes, yeah, we'll have it. In fact, I can print out some copies.
Adam, question. Obviously, going over these lists, I'm looking at item 15. I actually was appointed back in March. These last 2 years created some challenges. So technically, were we in violation during the pandemic?
Yeah, probably. I mean, but that's my flippant answer. The real answer is you did the best you could, and we all did. You're required as a homeowners association, whether it's a condo or a subdivision, to have an annual meeting. There really aren't provisions for having an annual meeting via Zoom. It doesn't really work. You can't take 250 votes via Zoom. You've got to do something else. So sure, technically you were in violation. But if you haven't gotten sued yet, you're probably not going to. Most owners in a community aren't willing to go hire a lawyer, spend thousands of dollars to fight about these technical violations when at the end of the day, what really happened? What are the damages? You still tried to get people to participate. You still had trouble meeting quorum. You still had trouble getting people to pay attention at all. And you still collected assessments, paid your bills, and moved on down the road. And so, that's not to suggest that there aren't people out there willing to litigate against their homeowners association. I make a living doing that. But you will most likely not experience, major financial repercussions because you weren't able to meet all of these requirements that I'm talking about now. Just know that they're there and do your best to meet them. And now that most of the restrictions that affected our ability to have in-person meetings have been lifted, go back to trying to do it the right way. I don't think the courts are going to get clogged up with lawsuits over technical violations of the property code with respect to in-person meetings during the pandemic. I don't see that as a big problem.
I mean,
Yes,
every, go ahead.
No, go ahead.
I think that every board is trying to expedite meetings as much as possible, and electronic votes by email seem to work real well, even with, obviously you got to do discussions as well. And then ratify at meetings. I would think that would cover everything, but it doesn't look like it does.
Well, your point's well taken. Ratifying it at the meeting is the key to that.
Right.
So you can discuss those things via email. You can have conversations with board members. You can get on the phone and go, what do you think about this? Then take all those decisions that you know you're going to make, bring them to the open meeting, let everybody hear you vote on them, get that into the meeting minutes, and you're good to go.
Just okay.
So exactly what you said is okay. It's the part where you don't remember to go and ratify it at the next open meeting where you've got a problem. So,
Can you touch a little bit on number 4, as far as compliance aspect?
sure. So this is a great time to talk about the concept of delegation. As a board of directors, as we talked about earlier, you're kind of the brains of the operation, but that doesn't mean that you necessarily have to make every decision. You should have, for instance, a collection policy. It would be pretty silly to pull out the list of delinquencies, go down one by one, and make a separate individualized decision about, are we going to proceed with this person, or are we going to let them off the hook? You have a collection policy that says if anybody owes over $750, we're sending them through the collections policy or collections process, starting at the first step all the way through to where they either enter into a payment plan or get foreclosed on. The same thing with enforcement matters. So you have an enforcement policy, you delegate the enforcement of that to the management company, and then you don't have to vote on every single action that takes place. You vote on that policy in an open meeting, sign it, deliver it to your manager, and now they're off to the races. And that does that has a lot of benefits that we can talk about later. But that's the way to handle these obstacles, is to have a policy that you've adopted for each one of these things without having to have a vote every time one of the individual items comes up. Yes, ma'am.
She called dibs first.
Question.
Number 11, approval of the annual budget. Okay,
Right.
so you know that we still are under the declarant
Right.
rule. Our
Well,
homeowners.
you guys don't
allowed-
even know who's on your board. So.
We don't, but we had a budget meeting, like a last December, and they approved it, but nobody got to see it. Are we not allowed to see it prior to them approving it? Or is that just for the board of directors to see?
Well,
I know we're different.
during the development control period,
Yeah,
a lot of these restrictions don't apply.
Don't apply, yes.
The land developers in Texas have a significant lobby. And so when the legislature meets to put a bunch of restrictions on HOAs to protect the homeowners from the oppressive board members like you guys, they give a lot of exceptions to developers during that period of time. And there's a lot of actually really good reasons for that.
Sure.
Nobody's going to invest money to develop a neighborhood if they can't do it how they want. And so that's one of the principles that I suppose apply. But probably you fell under an exception, and that's why the budget was passed without anybody knowing about it.
Yeah.
The developer can do that. Yes, ma'am.
So my question is
Question?
that.
Oh, hang on one second. We got one in there. Who's pregnant? Go ahead. You go ahead.
Oh, okay. So once we get to the point to where we as homeowners actually get control, or maybe even with the members of the builders board that we have right now, there's nothing in our governing documents that say, if you accrue this many fines because, your yard is yucky or whatever. If we decide that we want to enforce those fines because we're noticing X, Y, and Z is rampant around the community or whatever, would that require an amending one of the governing documents? Or is that just, we're placing this on file and it's an extra piece of paper that gets tacked on? How, like,
Well, you may not need that policy at all. I mean, I would encourage you to have a violation enforcement policy for regular things, you know, you leave your trash can out, you get a courtesy letter. You do it again, you get a $25 fine, that kind of thing. Have a fine policy and enforcement policy. But if someone is repeatedly violating the restrictive covenants and fines aren't working, then the next step is to file a lawsuit and request an injunctive relief. You don't necessarily have to have a resolution on file that says you're going to do that. You already have the right to enforce the restrictive covenants through any means necessary, certainly the legal process, without a policy on file.
okay, but kind of any of these types of, you know, an assessment increase, is there anything where that's supposed to be written that homeowners have access to?
I don't think I understand. I mean, if you have the right to increase assessments, you'll find that in the declaration. That's-
Okay, but do we have a right to be in writing informed of that to the homeowners?
Of the increase?
Yeah,
I have a question online.
Yeah. They can't increase the assessments without letting you know.
within writing.
I would think so.
Okay,
Again, I think you have some pretty specific stuff for your association that we probably have to look at, you know, specifically.
I didn't know if that was like an across the board thing that stuff has to be given to
That
homeowners
doesn't sound like it.
in writing.
Yes, sir. Had a question from somebody online.
Yes, I'm a new board member from the community. The other two members represent the developer. I've been on the board for 6 months. We have never had a board meeting. We've not elected officers, and they still seem to be running it as if all three are owned by the developer. How do I resolve this?
Well, you are entitled to notice of meetings, but as one person of three, they're going to end up being able to control almost every single decision. The requirement that the developer allow one board member onto the board is quite frankly kind of a bone they threw to homeowners. It allows you some transparency to know what kind of action they're taking as a board, but that's about it. You're just not going to be involved in a lot of the decisions. Now, if they're making some of the decisions and they're outside the development period and they're not giving you notice of meetings, but they're making these decisions that are included on this list of 15 without you, they may be acting outside of their authority. So again, that sounds like kind of a specific question related to your specific association. I'd be happy to talk to you about it later.
Thank you.
Anything else?
No, we'll try to keep the questions till the end, just so that we can get through the content, and then we'll come back and have open Q&A.
That sounds like a good plan.
Oh, sorry.
That's all right. All right, so let's see. Okay, so recording and taping of board meetings. Anybody attending or participating in a board meeting may record the meeting, and there's no requirement that you know about it. So they can do it secretly. They can have a little, secret lapel pin. They can do it with their phone, and you can't really make a rule to stop them from doing it. The teachable moment there is just act as if you're always being recorded, and you'll always be in good shape. Just know that there's really no way you can stop that from happening. All right, so moving on to membership meetings.
So that's a law.
That's the law, yeah. Moving on to membership meetings, I really like this cartoon. I get called all the time because the board is worried that the owners are sharpening the pitchforks and they're lighting up the torches, and they are going to be at this meeting, and man, they're going to have all these questions. We don't know what to do, and they're very, very angry, and they're probably going to yell at you. And then they show up, and there's 2 or 3 people in the audience. They ask one really nice question, and they move on. But the large turnout at the open meeting had the board a little nervous. It used to be you might get 3 people, and they're mad, and now you get 4. So anyway, we'll be talking about laws that govern the membership meetings, types of membership meetings, where to have your membership meetings, how to give notice of the meetings, what the quorum is, how to determine what it is, and how to vote, and what proxies name. Now, membership meetings are going to be primarily governed by your governing documents and mostly your bylaws. That's where you're going to find things like the quorum, the location, the frequency, and even the time. A lot of bylaws will actually state that, it's the third Tuesday of February. Don't panic too much if you're not following exactly what it says. The older the association, the more likely it is you've moved the meeting to some other month and you've been doing it for years. So membership meetings are also governed by Chapter 22 of the Business Organizations Code, the Texas Uniform Condo Act, if you're a condominium, and 209 if you're a subdivision. So there are actions that must be approved by members, the actual homeowners, at a membership meeting. So those things are anything specified in the governing documents, like the election of directors or the approval of a special assessment, and then fundamental actions. This is going to rarely come up, but there are fundamental actions defined by Chapter 22 of the Business Organizations Code, like if you were deciding to sell all or substantially all of the assets of the entity, or if you were trying to dissolve your association. Those are things that have to be voted on by the members. Now, there's two kinds of membership meetings. You've got your regular membership meetings. This is what you refer to as your annual. And then you've got special or ad hoc as needed membership meetings. An HOA is required to hold an annual meeting of its membership at the time stated in its bylaws. If the HOA fails to timely call an annual meeting, there's two ways that owners can demand that you fix that. And we'll go into that in a little bit. Anyway, who can call a special meeting? So if you look at your governing documents, it will indicate who's allowed to call a special meeting under Chapter 22 of the Business Organizations Code. If there's not in the bylaws, you can also call a special meeting by the president, a majority of the board of directors, members having not less than 10% of the votes to be cast at a membership meeting, or any other officer or person authorized by the governing documents. Under the Condo Act, it's similar, but a special membership meeting can be called by the president, a majority of the board of directors, or owners with not less than 20% of the votes available to the members. Now, how do you give people notice of the membership meeting? You need to check your governing documents and follow those, but in any event, the notice can't be given more than 60 days or less than 10 days before the meeting date. Subject to the governing documents, you can give notice by personal delivery, mail, fax, or email, but it has to be stated in your governing documents how to deliver that notice. If you are a subdivision HOA and you have at least 101 lots, you also have to provide a solicitation of interested candidates before you have the meeting. You've got to give this at least 10 days before you send out the ballots, and it has to give instructions and a deadline for notifying the HOA of the owner's interests. If then you have to mail it to the owners, or you can provide it the same way you provide notice of board meetings by posting it on the website and emailing it to everybody who's given you their email address. Then if people respond by the deadline that you've given and the deadline was reasonable, you have to list every interested candidate who timely notifies the association of their interests. What this really does is it abrogates the provision, if you've got it in your governing documents, that talks about a nominating committee. If you previously had a nominating committee come up with who the the people that are going to be running for election are, that's pretty much out the window. This is the way you get on a ballot. And if somebody sends you their name and says, I want to be on the ballot, you've got no way of keeping them off unless they've committed a crime of moral turpitude or a felony within the last 20 years. All right. So a quorum at an annual or special meeting of the members represents the number of members that have to be present at the meeting before you make transact business. It's almost always specified in your governing documents, and 99% of the time that'll be in the bylaws. If it's not specified, the quorum is established by 10% of those holding votes in the association being present at the meeting in person or by proxy. Unless it's modified by the HOA's governing documents, every member of the HOA is entitled to one vote. Most governing documents are going to allocate one vote per lot or unit. Of course, there's some associations where you've got weighted votes because of the interest in the common area, square footage, something like that. Now, some HOAs do have in their governing documents provisions that disqualify voting rights of an owner if they're not in good standing. That was usually defined as owing money to the association, being in violation of the restrictive covenants. These are not enforceable in subdivision HOAs, but they are still enforceable for condominiums. So if somebody shows up at a meeting for a condo association and you have provisions that say you must be in good standing to vote and they owe you money, you can prevent them from voting. In some instances, you can prevent them from running for the board. Unless the HOA's governing documents or statutory law requires a higher percentage, items submitted to a vote of the members at a membership meeting only has to be approved by a majority. For example, fundamental transactions, if you're trying to sell all or substantially all of the assets of the association, you need 2/3 of a vote. A lot of your governing documents will also indicate higher percentages for things like amending the declaration or approving a special exception. But it's important to read very closely what the language is. A lot of times the language will say 2/3 of those present at a meeting where there's a quorum, which is a lot different than 2/3 of all the members entitled to cast a vote. And so it's important that you know what your thresholds are for whatever it is you're trying to do. So there are different ways of voting. It's a little bit complicated as between subdivisions and condos, what's allowed and the methods that are allowed. So first and foremost, owners may vote by any method that's authorized in the governing documents. If it says that it's allowed in the governing documents to vote a certain way, then you can vote that way. Texas statutory law also authorizes these other voting methods, regardless of what the declaration or the bylaws say. So you can always vote in person, you can always vote by proxy, and in a subdivision, you can vote by absentee ballot or electronic ballot, even if your governing documents don't mention it. Now, if your governing documents say, and we shall never vote by electronic ballot, then you can't. But if there's not an express provision against it, then as the board, you can choose to allow absentee or electronic ballots as well. Unless it's otherwise prohibited in the articles of incorporation or the bylaws, members can always vote in person or by proxy at membership meetings. Now, voting proxies have to be in writing and they have to be executed by the member or the owner or the member or owner's attorney in fact. That just means their power of attorney. It's rarely going to come up that you're going to have somebody execute a proxy by virtue of a power of attorney, but it is possible. Now, to be effective, the proxy holder must actually show up and vote. I get this about once a year. Can I give my proxy to somebody else who then gives their proxy to somebody else, and then that person shows up? You can't do it that way. You give your proxy to one person, that's the person who can show up and vote. If they don't, then nobody votes for you at that meeting. So if you vote by absentee ballot, you have to include in the form the proposed action and provide the owner the ability to vote for or against it. And then you have to give instructions for where to deliver that absentee ballot. And then you've got to include this language that's here in this little box. All this is saying is that if you vote by absentee ballot, then if somebody makes a floor amendment to the provision that's being voted on at the meeting, and that floor amendment passes, then your absentee ballot is out the window. The idea there is that the measure is fundamentally changed by virtue of the amendment. And so the folks that were voting for or against, we don't know what they actually were going to vote on had they known what the amendment was. If that happens and these absentee ballots are thrown out, they no longer count towards quorum either, which is important to know. So floor amendments have a devastating effect on both quorum and absentee ballots. And in my experience, if you explain that to the members before somebody stands up and starts making all these floor amendments, the members are usually kind of discouraged from doing that, so that we can allow, if we've got a bunch of absentee ballots, we can allow those to actually count both towards quorum and to the actual vote. Now, you can also vote by electronic ballot. Some of you may have used HOA Vote Now or Election Buddy. I also know that there's a lot of folks out there that are using SurveyMonkey. I'm not sure that one actually works, but electronic voting is permitted. And it means that you're casting your ballot by email, fax, or posting on an internet website. That's Vote HOA Now or Election Buddy. They must be able to be cast in a manner where the identity of the lot owner submitting the ballot can be confirmed. And then the owner gets a receipt showing that they voted. Those are really the only requirements for electronic voting. If the electronic ballot is posted on the website, a notice of the posting that contains instructions on how to get access to the posting has to be sent to all the lot owners. So that's pretty easy. You just send them a link when you send them the notice of the electronic ballot. Now, if you're trying to choose a voting method, these are the things you need to know. Unless otherwise provided by your governing documents, members of a nonprofit in Texas have the statutory right to vote in person or by proxy. Subdivision HOAs have statutory authority to utilize absentee and/or electronic ballots, but owners don't have a right to demand that you offer either of those. And subdivision HOAs have the statutory ability to limit voting methods to only a single method. So you always have to allow in-person voting, and then you have to allow at least one other alternative. That means proxy or absentee. So there's always either proxy or absentee allowed, and then you always have to allow in-person voting. Voting by absentee and electronic ballots count towards the quorum unless the item's modified at the meeting. As I indicated earlier, that's important to remember. In general, ballots should be cast by owners according to the procedures specified in the governing documents. And if you're a subdivision, there are several laws that regulate how you cast and tabulate ballots. In general, unless the association adopts rules for the use of secret ballots, all ballots in a subdivision must be cast in writing and then signed by the person casting the ballot. Electronic ballots do constitute a signed written ballot. All paper ballots have to actually be signed. A subdivision HOA may adopt rules for a secret ballot vote. This is completely unnecessary. There's no reason to do that. It creates a lot of extra work for a lot of different people, but you can do it, and here's how. It has to be designed to reasonably ensure that a lot owner can't cast more than the votes they're allocated, and it has to require that the subdivision HOA counts each vote cast that the lot owner is eligible to cast, and it has to permit each candidate in a directorial election of secret ballots to designate a person other than themselves to observe the counting of the ballots. So again, it's a pretty extensive process to have these ballots that go into one envelope, and then that envelope goes into another, just for the purpose of protecting the anonymity of those voting in an HOA election. Seems like a lot of work to do that, but it is something you can do if you really want to. Now, when you're counting the ballots, 209 imposes strict restrictions on who can count these ballots. So candidates in the election, or if you're voting to remove a director, none of those people can have access to or tabulate the ballots. And then their relatives can't be the ones that count the ballots as well. The law actually specifies that you can't be within the third degree of consanguinity or affinity to one of these board members. All that means is you can't be related by blood or marriage. And if that's who wants to count the ballots, make sure it's somebody else. Any person that is allowed to access or count the ballots is expressly prohibited from disclosing to any other person how any particular individual voted. For some reason, they were very, very concerned with the legislature about the secrecy of HOA ballots and passed a bunch of laws related to keeping this stuff secret. And now we have to follow them. All right, so that is what I've got on board and membership meetings. Does anybody have any questions about what we just went over? Yes, ma'am.